Uh,
Yeah. Thank you, Mr. Goldston. You got to have your video on. These are issues with credibility and things of that nature. So you got to make sure your video stays on. So I'll know that you're hearing it. I'll know that you're present. All right.
Sorry. I didn't know it was still off, but I turned it off early when you went out. I'm sorry.
All right. I apologize, Mr. Rhodes. You can continue.
sure, Your Honor. Thank you. Um, and so what my client is asking the court to do is to return the children to her primary custody and grant the defendant standard visitation. We would also ask the court to just enter the child support worksheet and parenting plan that got filed back in January 2023. There's no reason for the defendant to have asked for all this new stuff in their 7-month late answer and counterclaim, except for getting mad at my client because she got pregnant by another man. That's the only reason that we're here, is out of spite. So we're praying that this court enter a divorce between the parties, that it award my client primary custody with the defendant getting visitation pursuant to a standard parenting plan schedule, that this court equitably distribute the assets of the marriage. I don't think that's really an issue, but to the best that we can tease it out through testimony, that my client be awarded in primary, be the final decision maker for all important issues, education, religion, extracurricular activities, and non-emergency medical, and she be awarded child support pursuant to the guidelines of the state of Georgia, and that she be awarded attorney's fees, and having to come deal with this after this case being settled for 7 months, and then deciding to file an answer and counterclaim with no cause, with a no cause divorce, with it's irretrievably broken. And that's my opening statement, Your Honor.
All right. Thank you, Mr. Horace. You're on mute if you're talking.
Thank you. Oh, I was trying not to interrupt Ms. Rose. I made sure I was on mute. Lots of things. All right. Let's just kind of do some of this in reverse order. Thank you, Your Honor. As you know, I am Donald Harris. I represent the respondent. This is the second final trial date that I've appeared at. The last one I was there by myself with my client. I think it's important for the court to know that when Mr. Rhodes asked for attorney's fees, we're having to do this again. We were here the last time. This is in addition to the other time where they wanted to continue the matter. So our prayer for is going to be a denial of their attorney's fees. Now, with respect to how we got here, it is true that a petition for divorce was filed on January 26, 2023. It is true that my client filed an answer and counterclaim on July 13, 2023. If the petitioner is contending that there's no issue here and that there was an agreement between the parties, the proper remedy would have been for them to file a motion to enforce. That has not happened, wasn't filed, it's never been brought up. So I'm not sure why Mr. Rose keeps talking about there's an agreement and the court should enforce an alleged parenting plan and alleged child support. I'm not sure where that's coming from. There is also no temporary order on any issue. So any proffer of the mother having primary physical custody since day one is just factually not correct. As Your Honor knows, when parties are married, until the court issues an order that says otherwise, the parties have joint physical and joint legal custody. That's the law. So for him to proffer that the mother's been the primary physical custodian is factually not correct. Also because the children are with the father. They have been with the father for months. If, again, I'm doing an opening, I can say my arguments for later. With respect to what the evidence is going to show today, the evidence is going to show that it is in the best interest of the children for the respondent, the father, their primary physical custody of the minor children. The evidence is going to show that he has been functioning as the primary caregiver, primary physical custodian of the children for months. The evidence is going to show that the kids go to school attached to a school attached to the respondent's address, and that has been true for months. The evidence is going to show that when the children were in the mother's home, her romantic partner inappropriately touched both of the children, and that the father made a report to law enforcement and to DFACS. Based on those reports and DFACS investigation, he was instructed to keep the kids with him. That is attached to the answer that we did to the motion for contempt. That's what the evidence is going to show. The evidence is going to show that it is true that the petitioner gave birth to another child during the marriage. The father is not the respondent. It is a different man. It is not the husband. It is not the respondent. And as we said last time, we want the order to address that issue so that it is clear that the respondent has no legal responsibility to that child financially or legally or otherwise. The evidence is going to show that the respondent did submit a domestic relations financial affidavit. And on that affidavit, it indicated that his gross income is $6,000 a month. And the evidence is also going to show that we did submit a child support worksheet, unlike the petitioners. With respect to marital property, there is none. The parties have been separated for years. The parties last separated December 1st, 2021. So they literally been separated for years. And during that time, the mother has taken up with someone else and again had a child with that person. I don't know how old the child is or the child's name because that information has not been shared with us. So I'm not sure on the particulars of that child. With respect to the child support, again, we're asking the court to utilize our proffered child support worksheet, which was filed with the court on December 2nd, 2023. Again, Deb's going to show there is no marital assets to be divided up. There is some credit card debt that will be discussed. With respect to our prayer for relief, we're asking that the court rule that the respondent is the primary physical custodian of the minor children, that the court grant joint legal custody to the parties, and that with respect to this final decision-making, that in all four categories, that goes to the father. And again, with respect to child support, we're asking the court to use our child support worksheet. With respect to a parenting plan, we would be asking for a standard for the mother. We would want that visitation to be supervised if she is still with the romantic partner that engaged in the illicit inappropriate activity with the children. There's been some rumors that they're not together anymore. I don't know. If they're not together anymore, that kind of sort of resolves that issue with respect to that individual. But if they are still together, we will want some protections in place for the children when they go over to the mother's home. With respect to attorney's fees, we asked the court to grant us attorney's fees. Again, we're doing this for the second time. And that ends my opening statement.
Okay. I trying to think if that somehow. So with you said the children were placed with DFACS. DFACS took the children and placed them with Mr. Goldston.
No, Your Honor. No, I'm sorry. No, the children. Mr. Goldston became aware of the romantic partner touching the children. He went to DFACS and filed a report along with filing a complaint with law enforcement. And then DFACS said, keep the children. I just want to be clear. I don't want to mislead the court.
Right. And so keep the children until we complete our investigation. Mr. Rose said they completed their investigation, but he continued to keep the children.
No. Our understanding was keep the children until Your Honor rules on this divorce and custody.
Okay. And then my second issue is that there is an allegation of abuse that almost stops me right now because I I can't make a decision without any background information. To me,
Would you want DFACS's investigate their report?
well, I think you need a guardian ad litem. Because
Okay.
you have an issue dealing with a child being touched. And those things are significant. And I can't make a decision based upon the DFACS investigation. First of all, probably I won't be able to determine how significant it was, for one, because usually the files I've seen are not very detailed as to what the investigation entailed. I mean, generally, I guess it's DFACS. You think they're doing what's in the best interest of the child, but for me to make a decision, I need to have boots on the ground. So I'll know what's going on with the children and who made how old are the children?
Your Honor, the children are 9 and 8.
Okay, 9 and 8 is a significant age. They should be able to. I'm sorry that Ms. Golston is saying that's not correct.
No, my children are 9.
They just turned 10 and 9.
Oh, 10 and 9. Okay.
Yeah.
Yeah, so 10 and 9 is significant. And Mr. Golston, when you say the children were touched, what are you talking about?
Well,
Mr. Golston, go ahead.
I did. Well, it came to my attention that my kids was telling me they had been concerned about being touched, about my wife's boyfriend that lives with her.
I know. I'm saying, what was the touching they told you about?
Well, he was stated that on multiple occasions he would kiss her on the mouth and on her face, and it bothered me. And then she said he would sometimes hit her on her behind, and she told her mother a couple of times that she felt like that wasn't something somebody grown should do. And that's what was said to me. And Levi said the same thing. Well, Levi said somewhat of the same thing, but then Levi said he was bullying him a lot.
So, Your Honor, the allegation is the kissing on the mouth.
Mm-hmm.
And none of that is true, Your Honor.
Okay. Have you had a chance to speak with your children before you say that's not true, Ms. Golston?
Yes, I did.
Oh, you do speak with them?
They via text message. They came by my house for 30 minutes and they spoke with me about it. And they said that most of it, their daddy made them say the things.
That's a lie. They have been.
It doesn't matter because I can't. And are you still with the person?
Yes, I am, Your Honor.
Yeah, we got to stop the hearing. I'm sorry, Mr. Rose. I can't hear you if you're talking.
I'm sorry, Your Honor. I didn't realize I was muted. So two things. First, I had wanted to move for a guardian ad litem in this case. My client can barely afford to pay me. And so that was the reason we did not ask for one was because she just doesn't have the funds to pay paywall. I agree that when there's allegations like that, that's the right call. That's what has to happen. She's just in a very difficult financial position. From our perspective, these are allegations that are unsubstantiated and that the father's making. And so we ask that he be financially responsible for the guardian.
So what's the income for Ms. Golston?
$1,942 a month, and the respondent is $6,000. It's a massive difference.
Right. So, and
Your Honor, may I?
Yes, Mr. Horace. Mm-hmm.
It is true that my client makes $6,000 a month, but it's deceptive given all of his other obligations. Would the court entertain possibly transferring the case to juvenile court for a guardian ad litem?
No, I won't.
It would help both parties with
I
costs.
object to that.
First of all, it takes a while, and they're swamped, and they kind of made that information known to us. The alternative generally would be, DVLF, but because he makes $6,000, you're not going to be able to pull him out of that.
Right. No, I understand, Your Honor.
Right. And because he makes significant, he's going to take the lion's share of this, even if I can reallocate later, depending on what the findings are.
We just asked that the parties share in it, Your Honor, to not just be one party.
And Your Honor, despite what the respondent's counsel stated earlier, my client did submit a child support worksheet back in January when this case began, showing her income at 1942 and the respondents at 6,000. So pro rata would be 75% to the respondent and 25% to the plaintiff.
Well, a little bit less than that, but that's what I'm going to do at this juncture. So I'm going to do 25, 75 of the guardian ad litem fees. So we can try to find a guardian ad litem. Give me a moment. I'll see if we can look at the court files and see if we have some guardian ad litems that can move fast and not, with a low retainer and hourly fees, and see if we keep it.
I do know that AVLF has some guardian ad litems that will do it for a reduced rate.
Yeah, and we'll try that. Well, I know sometimes they'll do a sliding scale, they'll do it at a reduced rate. We can see what that and see if we can get somebody. Yeah, let's try that first.
Okay.
So DVLF first to see if we can do a sliding scale, or kind of like at a reduced rate. We can see, since we have one parent, with financial. I think because you have older children who can talk and could probably, it should move a little faster than like if you had like an infant or a year-old. So it should be something that we can get done. I do need everybody to move quickly. Then they will ask you to pay $25 to start the process. You need to do that quickly. They might even ask for some financial information just to see what you make. You need to respond quickly. The faster you respond to the information, the quicker we can get somebody set. If for some reason they're like, we can't find anybody, then I'm going to pick someone from my list that has a low retainer and hourly. Like I said, because I think they're, the children are centrally located. They're not like out of the state or anything. And, they're of age where you can communicate effectively generally with them. So do we have any issues to be concerned about? Like, can they communicate?
No,
Yes.
no, Your Honor. They're very, very verbal, very articulate, very smart. Yeah.
Not an issue.
All right. So then that shouldn't be an issue. So we can get that started. I'm going to just be honest with you. This is going to throw you probably at least 3 months out. And so we need to put something in place until we handle it. Ms. Golston, do you live with the person that these allegations are being made about?
Yes, ma'am.
Okay, so we got an issue because we got to figure out how you want to handle it. I got to put some protections in place for the children. How do y'all want to think through what those protections potentially can be to be offered so that we can give you the visitation for the children and also kind of figure this out? One of the things though that is a good thing, a good at least consideration, is that generally we're in the middle of the school year. We don't want to change anything anyway. So we're talking about March, April, May. By the time we're done, they would have completed a school year in one location, and that way wherever they go after that, as long as we take care of this short, in May or early June, that way we'll know potentially what school systems and things of that nature they will be in. But they'll remain in the school system they're in now anyway. And Ms. Golston, I don't know exactly what your circumstances are, what you want me to do. I'll be open to, what you think would work so that you can visit with your children, but I need to put some protections in place for them.
Yeah, they can come to my mom's house.
Okay. So you'll visit with them there?
Mm-hmm.
Without the person that the allegation is being made against?
No, he won't be there.
Okay. So let's do Thursday, and you can return them to school on Monday, and you'll do from Thursday to Monday every other week, so that, let's see, how do we do that? I may have to do like a 2-2. Now, Ms. Golston, for visitation at your mother's home, are you saying that you would go there you be okay with going there like half the time of the weeks? Like, for example, if I were to split the custody up between the two of you, you would be your children would be going to your mother's house for those the plans. Because I'm thinking maybe I can do a 2255 plan basically while we're doing this, so that you'll still both basically get 50-50 custody while we're figuring this out.
Okay.
But it would have to be at your mother's house.
Yes, that's fine.
And who's the person? Can you tell me the name? Okay. So.
You want me to draft an order, Your Honor, that has that in there?
So a 2255 plan, that's kind of what we'll do. They'll remain in the same school system. Mr. Fleming, of course, will not be able to reside at the mother's house, cannot be around the children during this time period. And then, of course, wherever you live after that, you could return back to your home on the days you don't have the kids. But when you do have the kids, you'll be visiting with them or you'll be having your parenting time at your mother's home. And Mr. Rose, since you're going to do it, you'll be able to get the address for the mother's home. Make sure that address is in the system. Pick up and drop off will be from the school.
I don't know what school they go to, Your Honor.
When Mr. Rose does the order, I'll include it, Your Honor.
Oh, I thought you told me they went to the same school that they were in the father's school district.
No,
they are, but she's saying she doesn't know, which I don't know why she doesn't know, but he shared it with her. All I'm saying is I'll make sure that it's actually specified in the order.
Honor, I don't know where they are. I haven't even seen what school they go to. The kids said they went to a lady house for education.
Can we just say what school it is?
Mr. Golston?
The school they was going to was Rock.
But that's not the school they honor.
What do they go to now?
They are in homeschool right now. They're certified teacher.
Okay. Why are they in homeschool, and why'd you switch them out of school?
Well, they was going to because all the situation was going on. I wanted to just put them in homeschool and make sure everything's right until we got done with the courts.
So that I wouldn't be able to see my children, Your Honor.
That's a lie. They went to school in my house for the last 2 years. What do you mean?
No, they didn't.
Okay. Let's just stop. Okay.
Yeah.
All right. So we'll do that. And let's see.
Well, I'm sorry.
Can I say one thing, Your Honor?
No, Mr. Golston, no.
Right.
You had said pick up and drop off was going to be at school, but they're not in school. Where do you want me to put it?
Well, they're going to go back to school. They're going to go back to Rock Ridge.
Okay, they're going back to Rock Ridge.
Right.
Got it.
How long have they been in this in the program?
The homeschool program?
The homeschool
Yes.
program.
Since after Thanksgiving holidays.
Okay. After Thanksgiving.
Yes, after the holidays was over. Yes, ma'am.
And what kind of program are they in? Where it's their online program
They go into a home that has a school set up. She's a certified teacher. She has like a class of 5 people. And
okay. So it's a place you take them.
Yes.
Okay.
They have all the schools set up.
So she could take them there and pick them up from there.
Yes, ma'am. And she can get online access to a school dojo and class and a Khan Academy.
Okay. Where is that place?
That's in Lawrenceville.
You drive from Lithonia all the way to Lawrenceville every day?
From Stone Mountain to Lawrenceville. Yes, ma'am. She was the best teacher I've seen. I looked at her reviews and everything. So that's what I do.
How do you pick them up?
I go and pick them up. I drop them off and pick them up.
What time do you pick them up?
They get off around 3. On Friday, they get off at 2. They get out at 2.
So you pick them up at 3 o'clock?
Mm-hmm.
And take them where?
Take them back to the house.
And are you at home, or who stays with them when they get there?
I have my oldest son that stays here, but I'm here I'm here when I pick them up.
So when you come back at 3, you're at home.
Yes, I can be. Yeah, I'll be at home most of the time. Yes, ma'am.
And the other times that you're not at home, who's home?
My oldest son.
And how old is
Who's an adult, Your Honor? His son's an adult.
Yes.
Oh, and
He's an adult. He's 19 or 20.
okay. So generally, what time do you get them to your house?
After everything, it usually be about 3:40, close to 4 o'clock.
3:40, 4 o'clock.
Yes, ma'am.
And do you know where Miss Golston's mother lives?
Yes, she stays in Camp Creek, I believe.
She's not in DeKalb. She's in another part of town.
Yes, she's in Camp Creek. So it would have to be, we have to do a meetup halfway somewhere. Or she,
So Miss Golston, where do you live?
I live in Douglasville, Your Honor.
You're in Douglasville.
Yes. And that's where the kids were at school.
They were in school in Douglasville.
Yeah,
Ma'am.
I have
So
there.
they went from Douglasville to Rockbridge to this
No,
school.
prior they went to Rockbridge before their mother just took them out and took them to Douglasville. I have the information that shows that they were going to school from my house for the last 2 years.
I think what he's saying, Your Honor, Rockbridge is in DeKalb County, correct?
Mhm,
Right.
Yes.
Yeah.
5 minutes
Yeah.
from my house.
Okay.
Yeah.
But when you got them back, you didn't take them back there, right? You went someplace else.
Yes, because pending this case, I wanted I didn't want to put him back in, and then we have any issue. I didn't know what was going to go on, so I just put him in homeschool, and that's where we've been at so far. But I can put him back in Rockbridge.
Yeah, Your Honor, can I make a suggestion? I think what you said in this, Your Honor, about them in Rockbridge is the correct decision. A, that's where they were going to school, and B, that's within your jurisdiction. If something goes sideways, it's in DeKalb, not some other county.
My concern, though, is that they've been at that place for a significant period of time. We're about to bring them into a whole new school system for 2 months.
That's fair.
And
That's fair.
I think that
That's fair.
we're flipping them too much. They were already in one school because she said they were there until
They were
it was in
Eastside Elementary.
to November. Then they left there and went to another homeschool. And then I would be taking them from a homeschool and putting them in Rockbridge. So they would have had 3 changes in 1 year.
Your
Mr.
Honor, excuse me. They were out of school when I moved. And so they had completed at Rockbridge. So it was the summertime when I moved. And then when they started this new school year in August, they started in Douglasville.
Yes,
But she's not- but-
I get that part. What I'm saying, though, is that they've been, if I switch them to Rockbridge in the middle of all of this, they would have changed schools. They would be in 3 different educational environments in 1 year. So
Correct.
I'm trying to give them as much consistency as I possibly can. If Mr. Golston's intent was to keep them where they are and he drives them back and forth, we can continue to do that.
Mhm.
And then you can pick them up once he brings them back into the jurisdiction. So when he brings them back into DeKalb, then you guys would then find a place of meeting up. Because it can't be at school. What type of relationship do you all have? Like, do y'all have enough relationship y'all can feed each other, or are there issues?
There's
There
issue. I tried to speak with her on multiple occasions, so we just
No.
use it them. So, and she left it up. She said she wanted to speak through lawyers, so that's what I've been doing.
Okay, what I'm saying is, are there any issues of domestic violence?
No, never.
No, Your Honor. No.
That's what I mean. I mean, you probably,
No.
okay.
Never
Are
really
the
was.
children old enough and mature enough to get out of one car and go into another without assistance?
Yes.
Yes.
Okay. All right. So where would be a good place for you to meet, say, in Atlanta? Where could you meet?
I can meet her at Gresham Park if she wants to meet there. I
That's
think
far,
that's
Honor.
They've met there in the past.
you said what?
That's too far, Your Honor.
Well, that's halfway between me and your house. That's why I did that.
No,
Okay.
it's not.
So where I tell you what, Mr. Rose, Mr. Horace, can you all find a halfway point between house to house?
We can.
Yes. Yeah, we
Okay.
can.
Okay, find a halfway point, a good place with good light, and with people.
Yep. Agreed.
But a place with a parking lot where it's not too crazy, where kids can get out of one car and walk to without issues. Put in there, Mr. Rose, that they are to stay in their cars when they do the park next to each other, and they stay in their car. The kids get out of the car and go to the next car.
Can I ask one question?
Yes, sir.
If I just need to assist them, like getting their bag stuff, I don't have any problem with her. We don't fuss and yell or nothing. So I don't have any problem once the kids transfer the cars. So my daughter, she loves to take all her dolls with her. So sometimes I be pulling dolls with me, and she be trying to rock. So that's why I said that. And my son like to bring his little toys too. So
okay, so Ms. Golson, are y'all okay with would that make you comfortable or uncomfortable if he assisted?
I just rather them grab their bags and come on.
Okay. So she would just make 2 bags. She'll have to make 2 trips to the car. Okay.
She has plenty of dolls, Your Honor, from at both homes. She has tons of toys.
Okay.
But keep certain toys with her though. You know that.
Okay. If you park next to each other, you can pop your trunks. You can move from one trunk to the next.
Okay.
And
no
we don't have any issues. All right. And then with regard to communication, you will communicate via text only. Okay. I want you all to get to a point where that you can do more than that. But for purpose of where we are now, I want you to text. Why you need to text? Because you're doing a 50-50 plan, which is a plan I generally don't do when parents cannot communicate. Okay. But because I'm in this odd situation, this is what I'm going to allow. But as a result, there is going to be things Mr. Golson is going to know about the education that you won't know, and he has to communicate. He'll have to tell you when there's homework, things of that nature. If there's a doctor appointment that's being made, or those sorts of things, I need for you to be able to communicate that information. Like there's something happening. Mr. Golson, do the children have cell phones?
Yes.
All right. So you can call the children's cell phone without calling Miss Golson. Cell phone. Okay. If you call the children, you want to talk to them, and they somehow don't pick up, you can text Miss Golson and say, hey, make sure the kid's phone is charged. I'm trying to call, ask them to call me back. You can text her for those purposes, but do not use her phone to start to talk with the children, particularly if they have their own. She'll just be told to charge it. And the same thing for you, Miss Golson. If you call Mr. Golson, you call the children and their phones don't pick up, you can text him and say, make sure the kid picks up my call, I'm calling, that sort of thing.
Your Honor, excuse me. Is there any way I can get her number? Because I've tried to send my number a couple of times and asked her we can communicate the text, but I don't have her information.
Miss Golson, if you can ghost your number, I don't really care. You can give them the real number. You can get you another device with a different number on it. I don't care, but you got to forget.
Your Honor. I was sending it to him. We were communicating through Messenger and those things, but I can't give him my
email. But I'm not all the time, so that's why I told her.
Okay, so we'll exchange text numbers. Y'all exchange other text numbers. And do the children have any extracurricular activities we need to be mindful of?
Well, Eva and Levi was in boxing. Levi was in boxing, and Eva was in gymnastics prior to their mom taking them and moving to Douglasville, which I then had to hold them up for right now.
Doing those things right now?
No. They still have the membership. I just
those things we'll take up later. This is kind of where we are, what we need to keep them where they have been. I'm trying to do status quo. Okay. All right then. So we got that taken care of. And right now, with regard to issues of child support. So we're doing a 50-50, but because Mr. Goldstein, you make more, that means your child support is you're gonna end up with child support.
Your Honor, with all due respect, but you're of course also asking him to pay 75% of a guardian ad litem.
It's his allegation, Mr. Horace.
Okay. That's true. That is true.
And the child support, he has to pay child support. That's just a part of the process. even if you do recognize, even if I were to do 50-50, 50-50 does not mean 50, the child support is 50-50. You look at the custodial parent. The custodial parent becomes the parent who makes the least. That's how the rules are cut out. And so she would be the custodial parent, even though they're 50-50. And that would be whether this is temporary or not. So what I would do is I would look at the numbers. I would see what numbers she would pay him and what numbers he would pay her, and he would pay the difference. Now, there is some consideration sometimes if, there was some extreme bills that were outstanding that you want to make some consideration for, but generally that's what I would do. Like if there was some health insurance or something that was premiums or something that was high for the kid because of some type of medical issue, or if he was paying gymnastics and boxing, I would give some consideration to those things. But the numbers are just going to be what the numbers are. Both of you should be able to figure out what that's going to be.
Your Honor, will the court give any consideration to the point that we were here before on a final and we're having to go, my client's having to go all this additional costs because they failed to appear. And now Your Honor is saying he's got to pay for a guardian ad litem and child support?
Right. And also with regard to you not being there, Mr. Rose not being there, I think I put in your order that I will take up the issue of attorney's fees, because I think if you wasted your time, then someone has to pay for it. So that
you did say that, Your Honor. I'm just asking for consideration in the context of discretion. And I know you haven't said what child support is going to be, but as you're figuring that out, that your court remembers that.
Yeah, but I get that, but I don't know if child support should be dependent upon whether or not they came to the hearing. I granted them the new hearing because I do remember that Ms. Golston was participating. I think we had that last continuance because she was having a baby. There's nothing much we can do about that.
No, that's true, Your Honor. I'm talking about the actual final that we were here for. We were here for several hours, and right. Mr. Rose did not show up. Neither was his client. Neither side showed up.
What analysis would I give for deducting child support because they were not here at the final hearing? What legal analysis would I put in the document?
Your Honor, I guess I'm not making that argument because you're right. There's not a deviation category where that fits in. I agree.
What would you want me to
I agree.
No, I'm asking. So what would you want me to take into consideration? Because what would be the analysis you want me to use?
Well, for me, it wouldn't necessarily be for the child support. I guess we go more towards the guardian ad litem fees. It's because, but for Your Honor granting the order for a new trial, we wouldn't have this cost. This is a direct result of us having to do this again. Now we have this additional cost.
This cost a month ago. The same issue would have been brought up.
Well, I don't even know if that would be necessarily true, Mr. Horace, because if at the hearing, if I had heard that the children were being touched by her significant other, I would have asked for a guardian ad litem at that point because I couldn't send the children back to her. That did not come up at the last hearing. I went back through and I was like, whoa, that kind of stopped me. Because when you first came on, my were, we're about to finish this case today, and I'm very clear about it. But when you brought up the fact that the children were being touched, which kissing is grooming. Kissing leads to other things. So consequently, I needed to figure out what is going on with these children. So as a result of that, if I had known that even at the latter hearing or the first hearing, I would have said, I need a guardian ad litem. Or I would have said, I need an in chambers with these children. Because sometimes I can have in chambers with them and make a decision. Like if you want me to do that, sometimes I can have an in chambers with the kid and I'm going, okay, I don't need a guardian ad litem. That has happened rarely, but it has happened where a kid will just kind of, what I heard is not really what they said. And sometimes that kind of brings that sometimes that can help move the case along a little faster. But I don't really know. And it could just be one of those things where it just stops. If you want me to consider that, I don't mind bringing them in and talking to them. But ultimately, if they say something inconsistent, we're going to be back at the guardian ad litem.
I see. Okay.
So
Your
here's
Honor,
what,
I just wanted to get that off my chest. I understand what you're saying. It does not. I acknowledge it does not fit into a deviation for child support. I acknowledge that.
right. So I think you all can take a look at the child support numbers and come up with what child support should be. I'll let you guys take a look at that because I think you're all in agreement on the numbers generally, right?
Generally, yes.
Okay. So look
Yeah,
at
I need to see Mr. Rose's worksheet, but generally, I think we're right. We agree on the numbers.
all right. And who's providing insurance for the children?
The
I am.
it's the what's calling. They get assistance from the state.
Yeah, through Miss Golston.
Yes,
Mm.
ma'am.
Okay. So of course that is not a deviation as well. And Mr. Golston, do you pay for the schooling that the children are in now?
Yes, ma'am. I pay for the cell phone and the schooling. I got the cell phone because I couldn't talk to their mother.
Okay, the schooling, how much do you pay for schooling?
$400 every 2 weeks
For both of them or for one?
for both.
400 every 2 weeks. So basically you pay $800 a month.
Yes, ma'am. Plus school stuff, and I buy I get them lunches every day.
I'm not going to all of that. But I will give some consideration to the $800 that you're paying for their schooling. All right, then.
Okay.
You all come up with those numbers for me. Tell me I want you to do the worksheet without this education component. I will consider a number that I will give in this, and I would deviate on my own. Just leave that portion blank.
Okay,
Submit it to me like you would without that consideration, and I will make an adjustment.
Okay.
All right.
Understood, Your Honor.
Your Honor, I got a lengthy order to draft. Can I recap with you real fast?
You can.
Okay, thank you, Your Honor. All right, custody right now is 50-50. We're doing a 2-2-5-5 plan.
Right.
The children will continue to go to the school that they are going to. We're going to get the name of it from the defendant. Mr. Corey Fleming shall not be around the children. When the children are with my client, it will be at her mother's house, the address of which will also be produced in the order. The meeting place for the exchange will be determined by the attorneys, and at the meeting place, the parties will stay in their respective vehicles, and the children shall transfer from vehicle to vehicle, including their bags, even if it takes a couple trips.
Mm-hmm.
A guardian ad litem shall be appointed by the court, and the plaintiff shall be responsible for 75% of that fee, and the defendant shall be responsible for, the plaintiff shall be 25%, and the defendant shall be 75%.
Mm-hmm.
And then lastly, with regards to child support, we're going to run the guidelines, cut the difference, and we're going to run them without the $800, I believe is $800 a month in tuition.
Yes.
We're going to submit that to Your Honor. And so we're submitting everything in Word so that you can make an adjustment on how you take that into consideration.
Yeah, because it's just for temporary child support. So
Am I good?
Yes, you're good. You got it.
Okay.
All right. Thank you so much. Y'all take care.
All right.
Thank you.
Thank you, Your Honor.
And watch out for the DVLF order, okay?
Okay.
Yeah.
All right. Miss Marshall, if you'll put that down on my list to get that DVLF order out.
Yes, ma'am.
All right. Thank you.
Did you want me to go check?